with the Russian court system.
But isn't there a special court in Moscow for the arbitration court to hear these issues? Or is that not something, you think you just default right into the courts there?
You go straight into the courts.
So if the seat of the arbitration, the official place of arbitration, is going to be really important here. Well, there's a problem here because they're telling us it's got to be cited in Russia.
Well, can I say something? I've got a lot of experience of negotiating with Russians, and one of the things I have discovered is you never actually know what they really want. And something that they put forward as being a deal breaker isn't at all. But they want something else somewhere else. Irena, have you experience of this?
You are just right to the point. That's why earlier I said that you have to ask them why they insist on that, because there is something strange here. Why they insist on dispute, if a dispute arises, to be under the Russian legislation between a Russian company and a foreign company. And this is really, really interesting. And probably there should be a mediator to help to find out what is the real interest of both parties. Why you don't want to be under Russian legislation, and why they would like to insist on that.
It's interesting, as an analogy, we actually have had some experience, for example, in India, with Indian companies putting forward, a dispute resolution clause that says dispute resolution in India, and they're very insistent. But the reason they do it is they know that nobody will ever accept it, and if they can act like they really want it, they can trade it for some other concession in the contract, for example, something on price or somewhere else. I've seen that happen. Well, you never know if it really happens, but you suspect that's kind of what's going on.
Well, it could be. It could be
part of the overall negotiation package that's going in.
Probably, because in India, you never know when this can end. A court hearing could take 10 or 20 years.
Don't even get me started with arbitration. We're touching a very sore wound there about time of arbitration.
Okay.
But let's stay. I raised India. Let's go back to Russia here. I've just checked in with the commercial team, and they find your proposal about hearings and conducting the arbitration in Russia, but having the seat of the arbitration somewhere else. They talked to the customer and said, well, can you explain to us what you mean by that?
It is technically a legal expression to say that the seat of the arbitration is going to be, for example, London, in which case the English courts would have jurisdiction over the conduct of the arbitrators. But the arbitrators could agree to sit anywhere they wanted. So they could have their hearings in Moscow or New York or wherever. But still, London would be the seat of the arbitration, and the English courts would therefore have jurisdiction over the issues arising over the conduct of the arbitration.
So as a practical matter, how would you do that? I suppose you're talking about the particular drafting of the dispute resolution clause, right?
Yes, and it is very simple wording. You just simply say the parties agree to arbitrate the dispute, and the seat of the arbitration will be whatever jurisdiction you want.
And then you have to say something else, such as the hearings shall be held in Moscow.
If that's what the parties have agreed,
right?
Yes.
And that doesn't move the seat. The fact
it doesn't move the seat.
Okay.
No.
And what do you think? Is that something that the Russian company might be willing to consider? Because they may have a legitimate reason to say they want to have the hearings. I mean, they may say, this is where we operate. We're the customer. We're buying. Why should we have to fly to London for to get expensive lawyers, or reasonably priced lawyers? I'm sorry.
I think the correct expression is reassuringly expensive.
Reassuringly expensive lawyers. Do you think that's something that we could propose successfully with our Russian counterparty?
It is very difficult to say because why mediation is not discussed then? When you're putting the clause.
Well, right. Well, I haven't gone back to talk to my folks here on the commercial team because they're not sure yet about this hearings, and it's still arbitration. So, and the customer hasn't yet accepted this, so we're still in a negotiation phase where we don't know what else. So, I guess you raise a good point. What's another tool or risk mitigating tool that we could put on the table?
Exactly, and it sounds like when you are propose to marry someone, you're talking about divorce.
But, come at me again.
A prenuptial agreement.
I mean, the deal breaker now is where you are going to have court hearing. And you are discussing the joint venture, actually.
Well, they're saying now, again, we've gone back to them, and the problem now is whether or not it's arbitration in Russia, seat of arbitration is in Russia, or seat of the arbitration is in Stockholm or London. You know, Stockholm used to be for many years the accepted place of dispute resolution.
Yeah, Russians like Stockholm or Paris, yes.
Or Paris. And I know why they like Paris. Russian friends like to go to Paris. It's a wonderful place. I like it too.
Yes.
Not to knock Stockholm or London.
Yes.
The question now is, we've got a problem in that the customers, we've gone back with your proposal about how we cast the dispute resolution clause, and they say, no, they want arbitration actually in Russia. They want it to be in Moscow. But they're willing to agree to arbitration before an accepted international institution, such as the ICC or the ICDR. Now, my question is, or any of the others, some other also large reputable institutions. Question, is there something else that we could put into this that might make it possible for us to consider accepting this degree of risk? For example, mediation. If ultimately our fear is being in court, would that be something that might create a cushion between the place of dispute resolution, Moscow, which we've all agreed is potentially, not potentially, it's less than ideal here, and the chance of that actually coming to happen?
I think that mediation is a good suggestion if you have a clause which ramps up the procedures. So it requires the parties to take the dispute to mediation before they can start an arbitration.
So mediation requirement. Because we're in a zone where we're really talking about accepting risk, right? We said this is less than ideal. If we take this, it's a contract. Again, they've said it's an important contract. We'd really like to get this. And they're not, but they've made the concessions, right? They've conceded, not the court's arbitration. They've conceded, maybe they proposed somewhere in the Kamchatka Peninsula, and now they're willing to go to Moscow, a place where you could actually get an arbitrator to go to from outside of Russia, or even within Russia. And but they're not budging on this point. And Tim has said to us, there's still risk if it's and maybe an unacceptable level of risk for some people by citing the dispute in Russia, the arbitration.
Well, you're limiting the issue that might be before the court to issues concerning the conduct of the arbitration itself, rather than to the dispute.
Right.
But you'll need to take Russian legal advice on the application of the clause under Russian law. That could be complex, not least because the Russian system does not recognize mediation in the way that English law does. So when I say I would suggest that you have an escalating dispute resolution clause requiring the parties to mediate first before they go to arbitration, I'm looking at through my telescope, my English legal background, where the English courts would require the parties to honour that agreement first. I don't think the Russians...
As a condition precedent to going to arbitration.
Yeah.
Well, and I guess the light in which we're casting this, or the way that we're looking at this now, is that by having an arbitration as opposed to being in the courts, we've avoided, as you said, one type of risk, which is the substantive determination of the courts. It's now going to be substantively determined by arbitration, assuming we can also get a reputable institution, let's say ICC, for example.
Yes.
We have the ICC court in the first instance that would resolve, hopefully, disputes about the conduct, the arbitrator's appointment or their conduct. And so there's even less, I guess, that potentially could filter, you would hope, to the courts.
Yes, I mean, you do need to check out as much